Hello and welcome back to another video on A-Level Law. Today we're going to be talking about juries, which forms part of the English legal system, which is on paper 1, criminal law and English legal system. We're going to start by looking at what you need to know under juries. And the first thing is qualifications, including disqualifications, ineligibility and excusals. We're then going to move on to look at selection, including vetting and challenging, then move on to work and role, and then finally evaluation. So first things first with qualifications. The most important part of this is that you remember to include disqualifications, ineligibility and excusals because they form part of the qualifications. Quite often the big mistake people make is they just talk about the three main qualifications and ignore the rest, and of course that's not going to be worth 10 marks to a question. So if we start with qualifications, the main qualifications is that the jury is aged between 18 and 75. They have to be on the electoral register or roll, and they have to be a UK resident for 5 years since the age of 13 or 5 years since becoming a resident in the UK. One of the qualifications is you're not disqualified, ineligible or excused, hence why you have to talk about disqualifications, ineligibility and excusals. Disqualifications, you're disqualified for life if you've received a sentence of imprisonment of 5 years or more. You're disqualified for 10 years if you've received a sentence of imprisonment of less than 5 years or any other sentence. And you're disqualified whilst on bail for the duration of the bail term. In terms of ineligibility, a person suffering from a mental disorder is ineligible and not entitled or not allowed to be a juror, and that's defined under the Criminal Justice Act 2003. A person lacking capacity, so for instance someone that can't speak English or someone suffering from a disability which results in the juror not being capable of acting effectively as a juror, they're also ineligible. So that would include people that are perhaps deaf or blind or with serious physical disabilities that are not expected to be jurors. In terms of excusals, these are all discretionary now, so it's up to the court to determine whether you can be excused or not. They are examples like booked holidays, exams, having a new baby, being a sole carer of a vulnerable person, or a business meeting that can't be changed. And most importantly, since 2003, the Criminal Justice Act, you can't be excused based on your profession. So that means doctors, judges, lawyers, etc. now have to be jurors. They can't be excused based on their profession. If we move on to look at selection, a really big important part here again is that this includes vetting and challenging. So make sure you include those even if, unless the question says otherwise. They are part of the selection procedure, and that's again a classic mistake that people make with selection questions, is not including those. If we look at the main selection, a central office computer will randomly select names from the electoral register or roll. They do this every 2 weeks, and they do this well in advance, obviously, of needing them. And they send out summonses to attend the local Crown Court. They send out about 250 per large courts. We're talking about thousands of people across the country being called up regularly to attend jury service. It's a £1,000 fine if you don't turn up, and when you do turn up you get a short training video and some instructions on sort of what to do and what not to do as being a juror. You're based in the jury pool for your time there for the 2 weeks, and when you're chosen, if you're chosen, a court official will read 15 names at random. If your name's on that list, you go with them to the courtroom where the official will then read 12 names at random, and then 3 of them act as reserves for those juries, and that is when vetting and challenging can occur. Once vetting and challenging has happened and they're settled with their 12 jurors, the jurors are then sworn in. In terms of vetting, there's routine police background checks which can be done to see if anyone's disqualified. That's approved of in the case of R.V. Mason 1980. And wider background checks which are much more controversial. They look for political affiliations, things like that. This is rarely used nowadays since the ABC trial in 1978 sort of brought the overuse to light. They can only be used now for exceptional cases like terrorism and national security issues, and they have to have the Attorney General's permission to do so. Challenging, there's 3 main types of challenges. The first challenge is challenge to the array. This is challenging the way the jury was selected, so i.e. it was biased or it's unrepresentative. So we can see that in Romford jury where 2 of the jurors actually lived on the same street. So the solicitor said, barrister said, this clearly isn't representative. R.V. Ford, the defendant tried to say that the all-white jury was not representative, but the judge shot that down and said no, because it's chosen randomly, that's just sheer luck or bad luck. So that's the way it is. So you can't, they won't adjust it based on race. It is literally just random based on who you get from the people that have been called off the electoral register. Challenge for cause is challenging a person's right to be on a jury, so that could be because of the connection of the case or because vetting has pulled up that one of them is disqualified or something like that. That can be seen in R.V. Wilson. And right of standby of jurors is only available to the prosecution, and that allows them to basically select one of the jurors to be put at the end of the list, which means one of the reserves will come in their place, essentially. But that is only available to the prosecution. To be clear, vetting and challenging doesn't happen all the time. It's the discretion of the barristers and solicitors, so it will depend on a case-by-case basis whether that occurs or not. Moving on to work and role, juries only sit in the Crown Court. They never sit in the Magistrates' Court. They hear indictable and some triable either way offences, obviously, because they're the only sort of cases that are heard in the Crown Court. And they always sit as a panel of 12, unless there's illness, in which case the judge can use their discretion to limit the amount of number. If one goes ill, they can carry on in certain circumstances, but we're not going to go into too much detail on that. The Criminal Justice and Courts Act 2015 makes it a criminal offence to intentionally disclose or ask anything about anything that happens in the jury room. So that means the whole process is secret. Juries have what's called a split function with the judge. The jurors weigh up the facts and evidence and give the verdict, and the judge will direct the jury on the law and deal with the sentencing. So they have basically a 50% part of the job each, essentially. Verdicts. All jurors are asked to come to a unanimous verdict initially, so that means all jurors have to agree on the same decision, either guilty or not guilty, etc. After 2 hours, the judge can allow a majority verdict, so that's 11 to 1 or 10 to 2. Nothing else would be allowed, but it's up to the judge determining, on the complexity of the case. So if it's a really complex case, they might say, no, go away and discuss it for another 2 hours before we'll allow you a majority verdict. So it's up to the judge's discretion there. Majority verdicts were only introduced in 1967 because of the fears of jury nobbling, which is sort of bribing or interfering with jurors to try and influence their decision. If a majority decision can't be reached, then, so that's 9 to 3 or below, anything like that, then the jury is declared a hung jury and a retrial is ordered with a new jury, which obviously is costly and not ideal in most situations. Jurors also do not give reasons for their decisions, and their decisions, as we said, are always made in secret. They will be asked to elect a foreperson out of the 12, and that's the person that stands up at the end and reads out and says what the verdict was. The judge can't ask the reasons why they came to that verdict. All they can ask is how many people decided each way if it's a majority decision. So that's all the judge can ask. Moving on to the final bit, which is evaluation, advantages and disadvantages. I'm going to go through each advantage and disadvantage in turn because the disadvantage is linked to the advantages. So we'll go through these. The top one is public confidence. Jurors, having juries is very democratic. The right to be tried by your peers, that goes back centuries to the Magna Carta and even longer in ancient Greece, although they were slightly different then. And Lord Devlin describes juries as the lamp that shows that freedom lives. That's always a big positive there. And generally the public are really satisfied with jury trials. They're seen as much fairer than other systems in other countries perhaps, or just the judge deciding. But there is risk of jury tampering and media influence still, and we call that jury nobbling. Jury tampering, that's another word for jury tampering. We saw that in the case of R.V. Twomey and others, and equally we've seen media influence in cases like Taylor and Taylor and R.V. West as well. So there's questions there as to whether you can get really a fair trial if the media is interfering. Jury equity, that's where jurors are allowed to decide cases based on fairness rather than what the law says, and we call that jury equity. We saw that in Ponting's case. The guy clearly broken the Official Secrets Act, but the jury decided it was fair what he did and acquitted him, and jurors are allowed to do that. However, that causes perverse decisions, and that's where the person should really be found guilty because they have broken the law, and you can see both examples of those in Randall and Pottle and Cronlid as well. So two different cases there where the person really should have been found guilty because they did break the law, but for some reasons the juries decided it was fair not to. It's an open system of justice. That means all members of the public can be involved in the justice system, which makes it transparent. You can see justice being done. It's quite often seen as your duty as a citizen, and it makes the law clearer because they have to make it simple so that what we call lay people that aren't trained in law, can understand it and actually apply the law fairly in cases. But there is a huge concern around lack of understanding. In a report by Cheryl Thomas in 2010 called Are Juries Fair?, in which she used simulated trials because of course she can't do actual trials or ask anyone because that would be a criminal offence. She found only 31% of jurors actually understood the directions, which obviously creates massive concern around the effectiveness and use of juries. Secrecy of the jury room, obviously it makes jurors, they're free from pressure, particularly from external influences, and it allows them to bring unpopular verdicts because they're not going to be criticised afterwards because no one can publish anything about them, no one can ask them anything about what they made decisions on, so it allows them to bring decisions which actually the public might not massively agree with. But obviously where it is secret, we've got no way of knowing how they reach their verdict, and we also can't do any research onto the effectiveness of jurors either because we can't ask anyone about it. So one more thing, we don't know how they're reaching decisions can be seen in R.V. Young, where they used a Ouija board in a hotel room, and R.V. Karakaya, where she did her own information, her own research essentially, and came in and brought it in. So there is some concern there about how they're reaching decisions. Finally, impartiality is a random selection, which means you should get a good cross-section, and that should cancel out any prejudice, balance of numbers, the fact there are 12 of them, and also no case hardening because they only sit for a maximum of 2 weeks, so they don't get used to it and then start getting harsher with their sentences or decisions. But there is huge concern around racial bias because we can see it in cases like Sander v UK, which is only in 2000, where there clearly was racial bias and the judge didn't actually do anything about it. And the European Court of Human Rights actually said the judge should have stopped the case when they took it there on appeal. So that's Juries. If you've enjoyed that video and find that useful, please subscribe to us on YouTube and visit us on Instagram at Law at Portsmouth College. And there'll be more videos coming out on English legal system, tort and contracts shortly. Thank you very much.